It seems to be working in 30 seconds. I didn't do anything different. I just put in the exact same details as before.
Yeah, I
We're
can
live,
see
we're live.
live streaming, Alina.
Yeah, it's saying it's live streaming.
Yeah.
Wonderful. Okay,
All right.
here we go.
Yeah. All right, great. We are back again at EU India People Summit. Today we are having a panel on impact of COVID situation in rule of law. As you know, rule of law is very interlinked with the values of respect for human rights and our democracy and equality, and it's very much important for our lives as such. So this discussion will look into how it impacts and like how much rule of law can be derogated in emergency situations like this. So for our panel, we have two distinguished speakers. First one is Manu Sebastian. Manu Sebastian is the managing editor of Live Law. Live Law is a comprehensive legal news portal which is committed to providing accurate and honest news about legal developments in India and around the world. Manu is also interested in strengthening the role of judiciary in constitutional democracy. He is a regular commenter on matters related to public policy and law, and his articles have been widely discussed. And we also have Professor Ritumbra Manuvie, who is a lecturer of law at the University of Groningen in the Netherlands. She is also the CEO of Foundation The London Story and is currently on a mission to stop hate speech and associated violence and promote accountability, integrity, and pluralism at all levels. She is also the co-organizer of EU India People Summit. So welcome to the panel. And first, let me also introduce me. I will be the moderator. I am Induja. I'm a human rights practitioner, and I'm also a student of law in Finland. So for the agenda of the meeting will be that Manu will start with a few remarks on the impact on COVID situation, and then we will go into a panel discussion as such. So I open the discussion to Manu. You can go ahead.
Thank you, Induja. Hello, everyone. So we are going to have a discussion on the impact of COVID-19 on the rule of law. So as I was saying earlier, India is facing a very disastrous second wave of COVID pandemic, which is destroying lives, and people are fighting the battle alone without any support of the system. Hospitals are running out of oxygen, medicine, people are not getting admissions, and the state is not able to support them. And the state has failed in protecting many of the basic fundamental rights of its citizens. So when we talk about rule of law, and in a pandemic situation, there are two perspectives of looking at it. So in one way, when you look at it, the rule of law, there is a narrow way of looking at it, a very literal way of looking at it. That is, when you think during a pandemic situation, the state is growing in its powers, because state is getting a lot of emergency powers to for the management of disaster and for the control of the epidemic of the pandemic. So and was lockdown, state can ask people to be confined to their own homes. State can penalize people who come out or go out, and state can impose travel restrictions, quarantine restrictions, etc. So the coercive phase of state is getting more strengthened during the pandemic period. So in that sense, you can say that maybe there is one way of looking at it. So the rule of law is getting enhanced, or rather strengthened. There are more legal restrictions on the rights of people, and the state is getting a iron fist, or state's arm of law is getting more strengthened due to its invocation of emergency powers. That is one way of looking at it. So you can say that there is more rule of law during pandemic times, because there is lockdown, curfew, and the citizens' rights are mostly confined and mostly restricted. That is a very narrow, literal way of looking at it. And there is another perspective. There is a wide perspective, which says that, which views state as, which uh, is viewing, which is taking the perspective of social justice or welfare. So, because during the time of pandemic, a pandemic affects the lives of people differently, and in a situation like India, where there are a lot of social inequalities, economic inequalities, and social hierarchies, the pandemic situation will be affecting different people in different manner. So the people who are at the uh, lower strata of the society, people who are daily workers, marginalized people, vulnerable sections, they'll be worst affected by the pandemic and the economic lockdown. So in that segment, the rule of law. So when we think from their point of view, rule of law means that the state should step in to ensure their welfare. State should step in to ensure social justice. State should be ensuring that vulnerable people and marginalized people, their lives are not devastated by the pandemic as well as the economic lockdown. And when we think from the context of India, uh, in that count, we cannot say that we can say that the state has failed on many counts. For example, last year, when the lockdown was initiated, when the lockdown was imposed, we could see a lot of images of migrant laborers, interstate migrant laborers. They were forced to walk hundreds and hundreds of kilometers to their native towns from their, not from the native, to their native towns, because they had no work. And so they had to go back to their native homes, and there were no means of transport. So the state had totally abandoned them. The state had abdicated its responsibilities. There was complete failure of rule of law in that sense. So these are two perspectives, I believe, which can be adopted to discuss this topic. So, one is whether the state should be a very coercive figure and enforcing strict lockdown and quarantine measures, etc., to control the pandemic. And two, whether the state should be having a more welfareist approach and should be taking measures to uh, ensure protection of social justice and welfare of the marginalized people. So these are two streams of thought I think the topic will be having. I think I'll now over to you, Induja.
Yeah, that's a great overview. I mean, to put it into context, that we could either go towards a very coercive, authoritarian way, if I can put in extra, or we could go to a welfareist approach where everybody is looked after in a democratic society. I think when we sign up for elections, fair elections and democracy, we are pretty much going for the welfare society approach. So I think when we think about the concept of rule of law, like one of the main element is also legal certainty. So again, to bring back to the perspective of COVID, we had a situation where the emergency or the lockdown was announced within a very few hours of preparation, comparing to where I currently live in Finland, where it was given like almost a week's time. That was a very different experience. Even still, there was some experience of hoarding of basically like toilet paper and alcohol, but still there was a time for preparedness for the people. So it also gives the effect of trusting the government and prepare and not panicking. How do you correlate that with the current situation?
So when the Indian situation is taken into account, the lockdown was declared with a notice of 4 hours. People had no time to prepare. It was like a bolt from the blue. And so that is one thing. So when we think about rule of law, we think about, as you said, legal certainty, as well as transparency and accountability from the institutions of power. So here, as regards lockdown, there was no prior notice, no adequate notice, and people were not adequately informed the reasons for imposing the lockdown. For example, last year during March 2020, the COVID cases in India were very much less and much in control. And now, when we compare with the present scenario, COVID is wreaking a havoc throughout India. And probably now is the time for a lockdown. And many doctors and many medical experts are advising lockdown. And the government is saying lockdown should be the last resort. So the government's executive actions should be based on sound reasons. That is the basic element of rule of law. And that approach is missing with respect to the approach of government towards lockdown. For example, in the Indian state of Uttar Pradesh, the Allahabad High Court, the state High Court directed that the state should go into lockdown. And the High Court's order was based on certain reasons. It was a well-reasoned order. The High Court was giving certain reasons. Of course, I mean, the court directing a lockdown is a very drastic measure. But the court itself had explained the reasons for taking that drastic step. The health system was collapsing. The court had even given the statistics. The health system was collapsing. The state is not doing enough. So the court was saying that if the situation goes on like this, the entire health system will collapse and the doctors will be exhausted and no one will be there to battle the pandemic. So that's what the state, so the High Court said that lockdown is necessary. But the government went in appeal and the Supreme Court stayed the High Court order. So when we look these decisions from the standpoint of rule of law, or rather from the standpoint of transparency and accountability, the government's decisions seem to be very impulsive and arbitrary. It's not supported by adequate reason. There is no accountability. People are not informed. There is no discussion. The parliament is not sitting, and we don't know who is taking these decisions. And of course, there is no press conference. There is no media briefing. Suddenly, the lockdown is declared, and this is how things are happening. And these are not the elements of rule of law which we have in our mind when we discuss the governmental actions.
I think Ritumbra has something to add. Please go ahead.
So if I can intervene on that, there are a couple of things when we talk about this rule of law and the certainty of the government action. And one of the major questions that comes to the mind is that who actually in the government has the power to impose curfews? Yeah, that's the first thing. The second thing is who has the power to impose curfew or declare a health emergency? Okay. And both these sets of power come from two different sets of legislation. The power to impose your curfew will come from your penal legislation, the penal codes and the administrative law surrounding it, the CRPC perhaps. The power to declare emergency because of a disaster would require that first the state declare it to be a health disaster. Okay, so in both these situations, it would require, if you're using the curfew power under the IPC, then it will require that you consult the state actors, because in IPC and CRPC, the first sets of power, because India is a unitary federal nature, the first sets of power is, the police power is in the hands of the state and not the center per se, right? So you use that. That means you basically engage with the state actors and you have states as a stakeholder. However, what we saw in the COVID situation in India in last year, that element was absent. The second thing is the Disaster Management Act, which requires that you once again consult with the district collectors, draw out a plan of disaster management, and then you can say that this is a disaster emergency, and then you impose a curfew. Yeah. Again, that route was not taken. The third, which is the constitutional power of emergency that we have in our section 350 to 370, I guess. I'm not fully on grips with it at this point, but those emergency power are also very limited by the rule of law itself, which says that you can have emergency if there is a public order need, if it is a financial emergency, or if it is an external military threat. And in all those situations, it is the president of India who imposes the emergency, not the prime minister coming at 8 o'clock and saying that, okay, it's an emergency situation, let's lock the country down. that can't be. So this is in some ways why it is very hard hitting on rule of law when it comes to the impositions of curfews in India the last year. I saw Anu perhaps had a question.
Yeah, I had a question. So we say that when parliaments stop functioning, people come on streets, and that's what we saw with the anti-CA protests and also the farmers' protests, right? But my question is, what do people do and what can we expect people doing when the judiciary stops working, So we have seen that the 5 Supreme Court judges came out, in the open a few years earlier. And even before that, we were seeing that, we were witnessing that the Indian judiciary was under stress, pressure, all those problems. But the situation is alarmingly decreasing. I mean, is serious day by day, So what fear, dread we should, or caution, we should keep it in mind? Yeah, anybody who would like to respond?
Manu or Ritu want to take this?
I think first Manu can give a perspective from the live law because he's been more engaged with the legal scenario in India, and then I can join in.
So I believe when it comes to judiciary, as Anubandh was telling, against the laws made by the parliament, you can have protests, demonstrations, etc. But it's not usual, or it's a very unusual thing to have a protest march or a demonstration against judiciary, etc. But see, judiciary is an institution which exists on the foundation of public trust, because judiciary, unlike politicians or executive, it's not coming through elections, or it's not accountable to people directly. So the judiciary's strength is its moral foundation, the foundation of public trust. So as regards judiciary, a check on judiciary will be to enhance the transparency of judicial proceedings and encourage a culture of critiquing judicial decisions, more commentary on judiciary. And so that will keep the judiciary in check. At least the judiciary's actions will be discussed in public. It's a public opinion is, I think public opinion can be the only check against judicial abdication or judicial transgressions. Because you an informed public opinion. So, for example, the people in the legal committee itself raising their voices against the judiciary and critiquing judgments, etc. So, and the court's functions are more happening in a very. Can you hear me?
Yeah.
So, so I believe so. Shaping the public opinion is more instrumental in ensuring that the judiciary is for constitutional roles. And in that sense, since I'm part of this legal portal Live, which is reporting on legal Indian courts. So I see my function as a person who documents what is happening in the court and exposes or informs public about what is happening in the court and comments about or explains the judicial decisions as well as the court hearings to the public, not necessarily to the lawyers, also to people from non-legal community as well. And this is increasing the public scrutiny of judiciary. So while a hearing is happening, when we check Twitter or Facebook, etc., we can see a lot of discussion on the court hearings. And these discussions are very sharply critical. People are having very strong opinions, and they are not, they are expressing it fearlessly as well. And they are not necessarily from legal background as well. So even common people are following what is happening in judiciary. And judges also, to an extent, they are also conscious of this public opinion, and they are also conscious of their own their image, the image of judiciary as an institution of public trust. So I believe that these public opinions and this opinion formation and public commentary can be a check on judiciary. That's what I feel.
Okay. if I can step in now.
Yes, please.
So with regards to Anu's question on the judiciary itself, that whether what is the role of judiciary, I kind of acknowledge the role of the live law first. That's what I want to do as the first thing, because we in the law, we always have this dictum that you cannot have it as an excuse that you do not know the law. The excuse of not knowing the law is not a real excuse, right? But in the real life,
Right,
and
right.
Alina is a legal sociologist here, she would agree with it. We have seen that people don't really know the law. So yes, you know basic principles of the law, that you should not go out and kill, you should not harm another person, you cannot cause grievous harm, etc. But there's so many nuances to law that people are usually unaware of. And that is a space where magazines like Live Law do come out to fill that knowledge gap in the society, and which is very welcoming space for for such initiatives to take place, because this knowledge of law is powerful. It's empowering to the society around us. At the same time, I do not agree with putting the judiciary into scrutiny, to be honest, because they are not the politically elected leader. Their purpose is not to appease the public. Their purpose is to apply the law, what it is. And I would like to give an example from Germany and Netherlands on similar situations which arose because of the COVID. So there were protests over here. People wanted to protest against the corona regulation, like they have been doing in a lot of other countries. And the government said that, no, we cannot allow protests to happen because of the emergency situation that we are in. And then the court went out to rule that curtailing this fundamental right of assembly of the people is not really within the scope of the government, because the fundamental right itself creates that rule of law, stops the state from interfering in the liberty of the people. That's why we have fundamental rights, right? The state can now impose certain methodological provisions saying that, okay, if you protest, you have to wear a mouth cap, or you have to stand 1.5 meters away. Those kind of methodological nuances or rules the state can introduce, but the state cannot take away the power of assembly itself, or the fundamental right of assembly itself. And this is a very beautiful example in that way, to say that why it becomes so important for the judiciary to basically apply the rule of law, and instead of be swayed by the public opinion or what is the morally or ethically right thing to do.
Yeah,
so
I think
I just wanted to clarify. I was not suggesting that the court should be swayed by or should be account or moved by public opinion as such. So I was responding to Anoop's query, what can be done when the judiciary is not performing its function.
Yeah.
So in that context, I was saying that a more vigilant or more informed public opinion can be a check on judiciary. And just in that context, I was saying that. And not that the judiciary should be playing into the gallery and appeasing the public opinion, of course, because public opinion is a very very fickle-minded thing, and it can change.
it can sway
and
this way or
rule
that
of law
way.
is something.
And we kind of agree with Manu over there,
And
because I am pretty sure Manu is also as skeptical of the judges swaying to the public opinion as most of us are. Isn't it?
Right. See, public opinion is something which is, when we think of rule of law, we think of stability and consistency, and public opinion is something which is totally contrary to that. So
does Anu have a follow-up question?
Yeah, just to comment on that. So yeah, I think I agree with Manu. He has answered. My question was basically in what way the frustration of people would manifest when the judiciary breaks down. That was the question, and in the context of India especially. So I think Manu has answered that there is more criticism, open criticism, that has happened, and perhaps it will amplify. But from Ritu, I haven't got the answer, if I may insist.
Okay.
What scenario you see happening? Whether it should be criticized or not, that's another matter.
Yeah, so to be very outright positivist over here, I would say that when the judiciary is failing to apply the rule of law, then it is actually just failing. The institution is eroding. Yeah, and I feel that with a massive concern because like in the recent times also when we saw the Rohingya judgment coming out, and we'll be discussing it again tomorrow, but we did see the judiciary failing to acknowledge the past precedents of law, or the fact that
Right.
the Article 36 of the Indian Constitution says that the international law is a source of law for the Indian interpretation as well. And judiciary just failed to acknowledge that. And rather, it went on to erode a jus cogens norm, which is of non-refoulement, by saying that the Rohingya Muslims can be sent back to a country where they are being persecuted and where there is an active coup going on. Yeah. So sorry to say this, but as a legal positivist, I would say that I don't see a very nice, happy, hopeful future of the Indian judiciary in the current context, until and unless we do get certain judges who are more, positive, in the sense positivist law judges, which are affirming to the rule of law principle instead of making ethical moral judgments. So yeah.
I think we will go to the more deeper into access to justice, but does Snehal have a question? Okay, yes.
Yeah, I do have a question. So when Ritu says that the judiciary is eroding, I partly agree with you, but what about high courts? I want both. I'm expecting both of you to like draw a distinction between the role of high courts and the Supreme Court. Like in recent times also, like last week, we saw that the Delhi High Court on 2-3 occasions asked the state and the government of Delhi and the central government to provide oxygen to certain hospitals. So like the situation in India is definitely very bad, but high courts are proving to be very proactive in the current times. Even the Madras High Court we've seen, but in contrast to that, the Supreme Court is kind of a bit subdued. So, would you like to elaborate a bit about the role of high courts and how, at present, when we are in a pandemic and India is not coping up with it, could you talk about the difference that you can observe in the functioning of high courts and Supreme Courts, and in that context, how would you put the erosion of judiciary?
Also, if I can, because I think the conversation is going towards access to justice, if I could also add something, because Live Law has been reporting during this pandemic and before that, like how do you analyze the difference of judgments coming out from both high courts and Supreme Courts at this point, especially during the COVID situation? Is it very pro people or pro government? How do you analyze it? If you could also add that.
Responding to Snehal's observations, so I also tend to agree with her to a great extent that high courts have been more proactive when compared to the role played by the Supreme Court. And even during last year during COVID, there was this huge migrant workers crisis, and many high courts stepped in. And see, when we are discussing the role of judiciary, we have to keep one thing in mind: the judiciary cannot micromanage everything, micromanage the functions of the executive. Judiciary does not have the resources, does not have the manpower, and does not have the expertise as well. So the role performed by the judiciary is that of a review function, essentially, and it has its own limitations. And probably the judiciary can also perform the role of asking questions, probing the government, putting questions to the government and asking, why are you not doing it? and engaging in a dialogue with the government. So the government is forced to explain to the judiciary. So the government will have to file an affidavit, put it on record, what explaining their actions, etc. And so that is so the judiciary can only perform a review function, and perhaps judiciary can nudge the government to do action. So last year, for example, I'll take the example of one high court, Karnataka High Court. So during the first wave of pandemic, the government had taken a lot of measures, and the High Court, simply by asking questions, got the government to overturn many of its decisions. For example, the government had issued a notification saying that the workers in factories, they will not be paid overtime wages. The Karnataka government had issued a notification, and the High Court asked, what is the basis of this rule? You have to explain. And the government had the order had no constitutional or legal basis. And after a few critical observations from the High Court, the government withdrew it. So there was no judgment. I mean, you won't find a judgment on that. There is nothing in the, I mean, 2-3 court sittings and few oral observations, and the government withdrew it. So that is a very good example. And there are many such examples from the Karnataka High Court itself. And this year, during the the second wave of COVID pandemic, the major crisis which India is facing is the shortage of oxygen cylinders in hospitals. People are dying because they are not people in ICU wards. They are not getting oxygen supply. So that's why many people are dying. Hospitals, big premium luxury private approaching High Court saying that we have only few hours of oxygen supply in our hospital. So in such cases, the High Courts have been intervened. Many High Courts, at least 11 or 12 High Courts in country, have taken suo motu cases, and they're monitoring the situation, and they're managing it very well also, and very effectively as well. I mean, you can't drastically change the situation. The High Courts have certain limitations, but at least, I mean, High Court's intervention, as Snehal was mentioning, Delhi High Court. So the Delhi High Court's intervention, at least it managed to save few lives, maybe 1 or 2 lives at least. I mean, that itself is precious. So, I mean, it's a very commendable job, and even High Courts have been doing sittings, beyond court hours, even on holidays, at late night hearings. We had night at 10 o'clock, 11 o'clock, etc. Judges are sitting. I mean, and since it's a video conferencing sitting, judges can hear from the residences as well. So that way, I mean, the High Courts have been doing quite a commendable job within their limitations, of course. And to that, when compared to that, I can't say the same thing about the Supreme Court as well. I mean, now the Supreme Court, 2 weeks back, the Supreme Court had also taken a suo motu case on COVID issues. And there was an apprehension, and the Supreme Court indicated in its order that since many High Courts are dealing with the matter, it's creating some sort of confusion and diversion of resources from one place to another. So the Supreme Court indicated that it wants to pass a uniform order on all these issues. So there was an apprehension that the Supreme Court was trying to take over all the cases from High Court and to deal with the cases itself. So and there was a lot of criticism against that. Many senior members of the bar, they spoke out very strongly against it. The press, the media, everyone spoke against it. And recently, the Supreme Court clarified that it has no such intention. It is only trying to look at interstate national issues. The High Courts will be free. High Courts will be at liberty to deal with the issues. And so this is one instance of how public criticism can probably create a rethink on the part of judges and courts, and how maybe public opinion can be a corrective force in judicial transgressions. Because in the subsequent order, the court clarified that it has no intention to stop the High Courts from dealing with the cases. So yeah, this is the overview which I had to now. Yes, please.
Yeah, so moving on, I think within the access to justice, we should also not forget about the lower courts. I think that is something that we also overlook many times when we look about the international or national perspective of things. Because of the COVID pandemic, most of the district courts and lower courts were not functioning, and there was a gap. And it was not just here; like it happened so countries like Hungary, like they literally closed down the courts in the pretext of COVID measures. So this happened in India also, and why I bring this also is like judicial institutions are underdeveloped, and there had been always policies that had been made to improve the infrastructure, including the information technologies to be brought in. But then it had not been effectively done. Also, the budget allowed for judiciary for every year is also very less compared to given to other sectors. And how do you see this? Like, has this poor connectivity how has this affected the rule of law situation in India?
So I'll answer it in two perspectives. So firstly, there is one positive note in the sense that the courts in India have been very quick to adapt to technology, even the trial courts as well. So the most of the courts in the country are now functioning virtually, and there is e-filing. Filing is through electronic medium, and hearing is through video conferencing. And the courts have very quickly adapted to the and I see it as a positive development as well, and it has kind of given a lot of flexibility to lawyers as well, in one sense. So I'll come to the drawbacks later. I'm just narrating the positive aspects of the development. So for example, a lawyer in southern part of the country, to present a case in the Supreme Court, he need not engage a lawyer in Delhi and file it, etc. He can directly e-file it from his own residence or his own place in South India, and he can also appear. So that is bringing down the cost for the client as well. So in that sense, there is an increased access to justice. In that sense, that barrier to access Supreme Court has been reduced. For example, a person in South India can easily approach a local lawyer, and he can appear in the Supreme Court as well. So I've been seeing such developments as well. So this is one positive aspect, but at the same time, there is another big negative impact as well, because in India, India is a country with a big technological divide. There is a lot of people in smartphones, and internet connectivity is, as per some reports, it's only about 10 to 15% of the population has smartphones and connectivity. So people without smartphones and internet connectivity, even lawyers also, many lawyers are not familiar with these aspects. So in that sense, there has been a creation of new barriers to access to justice as well. So this technological divide is definitely a barrier. And recently, the Supreme Court was thinking of setting up like kiosks in trial courts, etc., to help people without smartphones, etc., to present their cases and access their case records, etc. So that has to be done. So this technological divide has created some new barriers to access justice, but at the same time, as a collateral effect, some barriers to access justice have got vanished as well. So we don't have enough study. I mean, we need to have a good statistical study to get a clear picture about how I mean, for example, statistically speaking, the number of orders passed by the Supreme Court during its virtual functioning, and also during when compared to its regular functioning, it's more or less the same. I mean, the court's functioning, the output, the productivity has not gone down as such in terms of the orders passed, judgments passed, etc. So that is one thing, and it needs a more detailed study and more statistics as well. I'm just broadly saying two outcomes. That's what.
Yeah, and it's a very new development, so we are yet to see
true.
how it comes out.
Right. So it's a field which needs study.
Yeah.
Yes.
Yeah, and Ritumbra, do you want to add?
Yeah, I wanted to just bring the perspective from the European Union as well into this, because when we are talking about access to justice. And as Manu very rightly mentioned, that it has become more convenient for clients who can access the lawyers to just be present online. I just wanted to bring this that in a lot of ways, European Union and also most of the Western countries around the world, they are very quickly moving towards the use of algorithms and AI in justice delivery systems. Mm-hmm. Yeah, and this is something I'm very curious to see how that actually unfolds in a massive country like India, where even the traditional legal systems or the traditional, judicial systems are not very well adapted to even the internet or telephone sort of like video conferencing bits as well. So, but I did wanted to bring it out because I remember from one of the projects that I was involved in that we had this. This was to do with the family reconciliation project, and they created a sort of it's called the Hill in the Humanity Hub in Hague, and they created this platform where the parties can actually go and reconcile, and then fill parts of this reconciliation agreements and see in a visual format which parts of the reconciliation agreement is still iffy, and not to the satisfaction of the algorithm perhaps, or algorithm is showing that it's going more in favor of one party than another party, so they can come up and negotiate and renegotiate that till they arrive at agreement which they are all satisfied with, and move ahead with it and just give it to the court and say, hey, this is our mutual agreement, please sign it and convert it into a decree. And that sort of puts the entire system of judicial resolution to the person and to the families to basically mediate their own troubles and their own problems. So, which was also very interesting. And I wonder how this will actually unfold in India if in coming years. So, but that was it.
I think it's also, I think we should also remember that a major part of people are still not accessible to internet. So Are they also being excluded? Do you have any comments on that? Because we saw a massive migrant crisis, so how do they approach courts when they are closed, and how do they approach lawyers if everything has to be digitally done, even though we see a massive movement towards digitalization as such with the COVID situation, even in India. So any comments on that? Ritumbra, do you want to take on this? Or
yeah, I mean, as what Manu said earlier, that the access to justice is not equitable in India, and it has never been so. And we have not just seen like the existing social disparity becoming more entrenched into the whole system, as what we saw also in the migrant crisis. But there was one important thing, and that was the public interest litigation, which did happen, and which one may say is not exactly the positive way of applying the law, but the Indian courts have stood up and have time and again taken the liberty to go beyond the word of law and use their power of mandates there. So that is definitely there. But then at the end of the day, it just comes down to the fact that there has to be, if you base your judgments on the right to health, right to life, right to liberty, right to dignity, that should be enough to carry forward the apparatus of law in some ways. I think Snehal has a question.
So I have a question which is not related to access to justice. So in the beginning, Ritumbra mentioned the Epidemic Diseases Act, and I wanted to, so there's this clause that actions taken under the Epidemic Diseases Act by the police, by the executive, in good faith, if those actions are in good faith, then those persons, those people are immune. They cannot be arrested, and and I've seen, like, I came across certain reports that a few people who criticize the conduct of the government Few people who said that the government is trying to hide numbers. The situation here and here is very bad as to as against what the authorities are reporting, and then those people who were outing the government, if I may use the word outing, they were arrested under this act. So how does this tussle between the Epidemic Diseases Act, which is a very, very old act, and the rule of law, how does this, I mean, I would like to hear your views on this.
Yeah, so if I may bring in Agamben over here, perhaps the theory of use of emergency power by the state. It is kind of historically proven that the states across the world use the emergency powers to curtail the personal liberty and the liberty spaces in any kind of polity. Yeah, be it the kingdoms or be it the nation states or anything further welfare states that we would have. And in some ways, I see the use of Epidemic Disease Act doing the same thing, that you define a barrier of law and you say that anyone cannot say anything other than what the government is saying. And then you basically cut down on the personal liberties of the people by using the law itself. So that is an emergency state of affair, and that reduces the power of the personal liberty of the people that they have. And I would take it, I would try to define it with that. So over to you, Manu, perhaps.
Do you have any comments, Manu?
Yeah, so these are clear instances of abuse of law. The Epidemic Diseases Act is intended to control as the name itself is conveying, it's intended to take measures to stop the spread of the disease, quarantine, lockdown, etc., all those things. And criticizing the government, expressing opinion on the government machinery, etc., these are not things which are within the domain of the Epidemics Act itself. So this was an instance of the state abusing the law or misusing the law to suppress criticism. So it was a clear case of abuse of process of law. It was an abuse of law. And probably if that was questioned in the court, and if the court had probably applied the law, probably such actions would have been set aside. That's a different thing.
I think there is two questions. Anu first and Alina second, if I recall correctly. Yeah.
Alina hasn't asked any questions, so I will give her the preference.
All right.
That's kind of you. Thank you. I have a little bit of a sociological perspective to add to this, which I will then ultimately end in a question. But I first want to do a short spiel so that my question makes sense. I'm a social legal scholar / sociologist of law researcher. And as a person who's more embedded in the academic environment, the term rule of law to me, first, of course, needs to be defined. And the question that Sneha brought up with this, wait, is this rule by law? Is this rule of law? If law allows this, is it then actually not a violation of rule of law? That all boils down to the question of what law? Is it one, there's that thin idea of rule of law that just what is written by someone applies equally to everyone, and a more thick conceptualization of rule of law, which is the idea that you not only have legal certainty and non-retroactivity, etc., but also have human rights embedded, have wonderful leaders, a brilliant judiciary, and just have the utopia of a legal system. And one version of rule of law, if you kind of put it on the spectrum, is rule by law. It's this, just wielding law as a tool, being like, well, it applies equally to everybody, but the content is vague enough that it can be interpreted in different ways. If it says if somebody does something in good faith, that always rings alarm bells with me, because judges and lawyers are not psychologists. They're not psychotherapists. I don't even think a psychotherapist would say they know if somebody did something in good faith or not. And Therefore, I would like to ask to you if we say that by rule of law we mean this thick idea of having human rights embedded and certainty and a great judiciary, etc., then would we need to basically get rid of a lot of pieces of legislation before we can even talk about rule of law being ensured?
That's a very interesting question. Yeah, I mean, Ritumbra, yeah, please go ahead.
I can say, so that is the reason why I mentioned about the use of emergency powers to curtail the liberties of the people, because you have obviously this whole idea of personal liberty and, you know, fundamental freedoms and welfare state notion, etc. But at the same time, there is also the legal power of the state, which can at any moment turn from a Leviathan to a draconian giant to cut out the personal liberty state. And there has always been and consistently been tussles between where the scope of the personal liberty versus the state power. And state can use the emergency power in a way to absolutely boggle up or, you know, just reduce the personal liberty state. And that would indeed be pretty much the application of the rule of law, or rather rule by law. And we have seen that in the past, and therefore we need to be careful on what our governments are doing, and we need to have a consistent evaluation of their actions so that we do not end up losing too much of our personal liberties in the name of emergency powers of the state. So I hope that answers your question.
And I think,
Manu, do you want to add?
Right. So this was the broad theme which I wanted to start the discussion with. And thank you, Alina. You have articulated it in a better manner. So when we talk about COVID and rule of law, I was mentioning there are two perspectives of rule of law. One is this authoritarian state, you know, state can enforce strict lockdowns, curfew, etc., etc. And also there is this social welfarist and human rights perspective of rule of law. So what would be, as Alina has rightly said, whether it is ruled by law, you enact a lot of set of draconian laws and you apply equally to everyone, and you say, okay, it's applying everyone, it's applying every equal rule of law there. So that is one thing. So it's not just, you know, we have this classic, you know, jurisprudential test of rule of law, you know, certainty, non-retroactivity, etc., etc. Even all these tests can satisfy. I mean, even a draconian law can check all the fulfill all these conditions for rule of law. So will such a legal system be a just legal system? That is a question. That is a point of discussion.
Yeah, I agree. I think I also thank Alina for reminding us again that there is no proper definition for rule of law. So it's up to the government. I mean, when they want to interpret, they can interpret as,
yeah,
that's,
so it's a lot of subjectivity as well in law. So
yeah,
and
yeah,
that's
exactly
where the courts come in.
Yeah, exactly. So I think in Europe also what they have done is like there were Venice Commission, which had made a definition for rule of law, and then the European Code of Human Rights. They also interpret a lot on what is rule of law, and then I think respect for human rights is also part of it. So they are elaborating and making it. And then another thing, moving on from this, like we could also, I would like to know the perspective on. So derogations can be applied during emergency situations. In this case of lockdown, at least for India, it was not declared as an emergency, but it was done as an official lockdown. And how far can we go with derogations with regard to human rights? And how far can we derogate rule of law in an emergency situation? This is, I think we have to also remember this COVID situation is still an ongoing situation and it's not going. So can we still call it as an emergency situation? Are we yeah, I mean, like I think you understand my point. Like, how long can we do this?
So as regards COVID situation, the Indian government, what it did was it declared COVID as a national disaster. So when it was declared as a national disaster, so the government got the powers to use the provisions of the Disaster Management Act. So the Disaster Management Act gave a lot of centralized powers to the central government, overriding the state governments. So all the decisions were taken in a central level. So it was not like an emergency situation, which we had in 1977, etc. Not that kind of emergency situation. Not an emergency declared for a political goal. So this was an emergency, a kind of emergency declared for a the government using the powers of Disaster Management Act to counter. So all the actions by the government had a justification of public health emergency. So it was in the name of public health emergency, all the decisions were taken. So this is where the distinction between the previous emergency and the present situation comes in. When the government is using the term public health emergency, even the citizens, even the people would kind of align, or they would be more receiving or more accepting the restrictions as well. So that social contract of consent of the governed and the governed. So that is more. People are more willing to obey these restrictions because the government is using the ground of public health emergency. So long as the disaster situation is existing, maybe such powers can also will be there. It's an uncertain situation. We don't know when the COVID situation will vanish. So that is one thing.
Yeah, Anu, yes, go ahead. You had a question, and
right. No, I wanted to bring in some French perspective. So since last more than 1 year now in France, we have the health emergency which is in place. So which gives the government special rights to pass ordinances, to make laws without discussions in parliament and a lot of things, And this is quite surprising because the lockdowns that we had, even by the European standards, the one which was in place in France, especially the first one, was one of the most restrictive ones. So every citizen, for example, had to download an application. Every time he or she went out, we had options to tick a self-declaration. Either I'm going out for grocery or to meet my parents who are sick and all, such options. And this was checked many times, and there was fine of €135, And I have not heard from any other European country, such restrictive and with fine and websites, and self-declarations. So that's one point. So in general, in France, the perception I have is that the French government's ready, or society's ready response, governments rather, is to make laws. Whenever they have a crisis, be it terrorism, be it a social unrest, be any trivial matter, and they think by making a law, things would improve. And for example, just to give an example, a friend of mine said it's not a surprise that France is beautiful. It's just not just coincidence, because people do not have, for example, to construct their house in any way they want. There are stringent norms that laws, let's say, they have to follow. Of course, the house has to be architecturally sound, but it also has to be aesthetically beautiful in terms of choice of color and all that. So what I'm trying to say is that we look towards law as something which is required, necessary, but I'm not sure where to keep that balance. For example, when I go back to India, I remember in general, whenever the Indian society, the judiciary cannot handle something, the simple solution is to ban it. And there's so many things banned in India. I remember when the metro first came in Bangalore, I was drinking water on the platform, and I was told by the security guard, it's not allowed to drink water here. The escalator first came, so it's not allowed to walk on the escalator. So yeah, what I'm trying to say again is the general reaction of a society and its approach towards law and restrictions. I think it needs to be seen in a perspective. So if you have any comments on this, any experiences, please.
Yeah, I can say that in Netherlands also it's sort of similar, that especially when you're talking about the COVID situation, that the fines are there, and if you are found violating, then you can be heavily fined from the violations. And sometimes it becomes necessary, other times it is, as you mentioned, are unnecessary interferences. But then there is also this whole conception in the legal theory that the societies generally collectively agree not to follow a certain law if that law violates the social collective morality or ethics of the society of that time. So that also happens, and in that situation, it's quite beautiful to see that how the governments react to such situations. For example, there was a time where in Netherlands they enacted a law to restrict the use of marijuana for certain groups of people, but nobody liked that law, so nobody followed it. So yeah, those kind of things can happen. I see, hand raised, and I think we also need to pack up soon.
Yeah, I mean, to comment on how people react, like in China, they had the strictest surveillance with the COVID tracking system, and then people are generally accepting to it. So it's interesting how people react to different set of laws, and yeah, those experiences are very different. So also, I think yeah, we are one hour already, and then half more hour. Yeah, I think we could also talk about criminalizing the freedom of speech, because recently also Indian government had asked the Twitter to take down almost 100 posts saying that this was spreading misinformation, oxygen crisis. But then I just today read in Live Law that the Supreme Court had made a comment that social media posts where people are commenting and communicating their grievance on social media and internet, then it cannot be said that it is wrong information. So that's a very positive thing that was coming up from the judiciary. So there is also this tendency to criminalize anybody who is, criticizing the COVID crisis management, because people are also desperate in the other hand. So how can we improve this situation, or governments could do better?
So there are two issues. So firstly, the government action was not strictly against Twitter comments or social media posts criticizing the government. So the citizens, they had to take recourse to social media for getting hospital admissions, oxygen cylinders, etc. People were basically sending SOS messages through social media and Twitter. And many people, even like I personally know, many people actually got help through social media. The government was totally abandoning them. So they had to take to, in desperate situations, people had to make such moves. And the government felt that it was damaging its reputation and image. So the state of Uttar Pradesh, the chief minister of the state of Uttar Pradesh said that if anyone is making such false, so the chief minister said that many people were spreading false rumors through social media to tarnish the image of the state. And in fact, there were certain news reports of police registering cases against people who made such appeal for oxygen cylinders through social media, saying that they were not genuine demands. So it was in that context the Supreme Court said that you cannot clamp down on people's SOS messages through social media. And if that is taken, the Supreme Court very strongly said that if such actions are taken, the court will take contempt of court action. That's what the court said. And it was a very strong message sent by the court and much needed to. It was in that context it was happening. And also there is another aspect. The government of India had requested Twitter to take down certain posts which were criticizing the government's management of COVID. The government had given a green signal for the Kumbh Mela. It was a religious gathering, which I think, as per some reports, at least 10 million people attended from all parts of the country in the middle of COVID, and with no social distancing and no use of masks or nothing. And it was going to be a super spreader event with many people, many politicians, and as well as public intellectuals were questioning the government's decision to allow the conduct of this religious gathering during COVID. And so the government directed Twitter to take down such posts. So it was in that context it was happening.
Yeah. Yeah, I mean, yeah, as you said, it was quite a relief to see that kind of message coming from the Supreme Court. Is there anything that the other organizers have to say about, or we can actually wind up? Or is there anything that anybody want to tell about? And also from the attendees, if there is any questions, please, you can put it in the chat or question and A. And I think we can end this with a final question, like, because this COVID situation is also an ongoing situation. How do you see the future for the situation, like especially for the rule of law challenges in India as well as in Europe? If Ritu can add, like, what is the future ahead? Because is the situation going to be like this? Because one of the things that I forgot to also say, like, the legislation is not really functioning. It's mostly through executive orders. So there's quite a lot of uncertainties. And so what are the future, how is the future challenges going to be like?
Yeah,
Any thoughts on it?
Yeah, I mean, we have known through years that the application of law has always been uncertain, and especially also, if you remember, the administrative law and the role of discretion in the application of the administrative law played by the street level actors can create those positive or negative outcomes for the people in question in general in a welfare state. But having said that, I do feel that now is in some ways a more important time to stick to the rule of law and rather on the side of the personal liberties and the fundamental freedoms of the people than to go on the side of state power. And I say that because we are in a time of pandemic across the world. And the states do have massive emergency powers. And if we allow the state to use those massive emergency power to cut down on our liberties, then it is going to be a problematic outcome. And having said that, I also acknowledge that there are situations where the liberties, like, for example, assembly itself, needs to be cut down to be able to a certain right to health for everyone, for example. So those concessions have to be constantly made by the government as well as by the people. So yeah.
Yeah, it's a great thought. Manu, do you want to add something on this?
I don't know. The future is very uncertain. We don't know how this COVID situation, I mean, at least in India, we don't know anything about it's total uncertainty. I mean, I don't think you people can imagine the level of anxiety and uncertainty which we are. Even with respect to vaccination, there is no certainty. Everything is remaining, all the government assurances are remaining on paper. There is nothing on ground level. It's not translating into real action. People have to fend for themselves. So it's a totally chaotic situation. I mean, it's very, very worse. And I hope, the future generation will learn from these experiences and will strengthen our systems, will, think about changing our framework, our systemic framework, and we need to have a totally revamp our systems. And maybe we need to, maybe I don't think this generation can do. I have hope in our next generation. So maybe they'll learn from our mistakes and they'll strengthen our system and put in place good, rule of law regime. Not rule of law in the sense of rule by law regime, as Arina said. Rule of law with transparency and accountability and concern for human rights. And so I can only hope for a good future, although I'm not sure if I'm not in a
Of course,
very
let's not be
optimistic. That is the
astrologers.
mood here.
Yeah.
No, I mean, see, the mood here is very grim, so that's why.
Yeah, I understand.
So that's.
So I mean, I'm happy that you said the word hope and that we can look forward to a younger generation, because yes, it is true. It is kind of a grim situation, especially for India with the current situation. But let's hope for that the future will catch up with that we will catch up with these issues. Sorry for the background news. That's my.
That's the future generation.
Yeah, that's the future generation. Oh, yeah. Hopefully we will do better with the laws, and we will learn from these situations, and maybe make better laws, and also press, like the civil societies can press for the implementation, and work for a better future. So perhaps we can end the webinar if we don't have anything more to add.
So I think yes. So thank you all. It was a very wonderful session. It was nice meeting all of you. It was very enriching.
Yeah, thank you for joining, Manu. Especially, you are doing a wonderful job with the live law, and we all look forward to reading live law articles every day. So that's great. And thank you, Ritu, for your insights of jurisprudence, giving the theoretical backgrounds in between. And thank you, Alina, for giving the sociological aspects. And that's very important. Many times lawyers tend to forget that. We just go by the book and we forget the society behind or for what we are doing this. And thank you, Anu, for bringing many perspectives, and also the French situation, and Snehal also for the great questions. All right, so we are ending the event, and have a lovely evening and night in India. All right.
Bye.